What is mandatory continuing legal education? As members of the Integrated Bar of the Philippines, lawyers are required to complete 36 hours of continuing legal education activities every 3 years that are approved by the country's MCLE committee. The MCLE rule was set in October 2001 through the Bar Matter 850, aimed at keeping practicing lawyers in the country more current with the constantly evolving laws and jurisprudence. It also intends to maintain professional ethics and standards of the practice. Continuing legal education is required of members of the IBP to ensure that throughout their career, they keep abreast with law and jurisprudence, maintain the ethics of the profession, and enhance the standards of the practice of law. Of the 36 hours, at least 6 hours shall be devoted to legal ethics. At least 4 hours shall be devoted to trial and pre-trial skills. At least 5 hours shall be devoted to alternative dispute resolution. At least 9 hours shall be devoted to updates on substantive and procedural laws and jurisprudence. At least 4 hours shall be devoted to legal writing and oral advocacy. At least 2 hours shall be devoted to international law and international conventions. And the remaining 6 hours shall be devoted to such subjects as may be prescribed by the MCLE committee. Members of the IBP not exempt from the MCLE requirement shall be divided into 3 compliance groups. Members in the NCR or Metro Manila are assigned to Compliance Group 1. Members in Luzon outside NCR are assigned to Compliance Group 2. Members in Visayas and Mindanao are assigned to Compliance Group 3. Nevertheless, members may participate in any legal education activity wherever it may be available to earn credit unit toward compliance with the MCLE requirement.
Credit units are equivalent to credit hours. Credit units measure compliance with the MCLE requirement under the rules, based on the category of the lawyer's participation in the MCLE activity. For reporting purposes, members of the IBP would need to document their participation in these activities and submit proof of their involvement when they report their MCLE compliance. This could include certificates of attendance for seminars or workshops, copies of published works, or other relevant documentation. It's important to keep accurate records to ensure that all credit units are properly accounted for. Credit units are classified into 2 categories: participatory and non-participatory. Participatory credit units can be claimed for the following activities: attending approved education activities like seminar, conferences, or conventions, in-house education programs, workshops, dialogues, or roundtable discussions, speaking or lecturing, or acting as an assigned panelist, reactor, commentator, resource speaker, moderator, coordinator, or facilitator in approved education activities, teaching in a law school, or lecturing in a bar review class. On the other hand, non-participatory credit units can be claimed per compliance period for preparing as an author or co-author written materials published or accepted for publication in the form of an article, chapter, book, or book review which contribute to the legal education of the author member, which were not prepared in the ordinary course of the member's practice or employment, editing a law book, law journal, or legal newsletter. For reporting purposes, credit hours refer to the actual time spent in an education activity. This means that if you spend time in an approved education activity, you should record the exact duration of your participation. This time is then converted into credit hours. Credit hours are given only for the time spent in legal education activities which have been previously approved by the committee and conducted by an accredited provider. This rule ensures that professionals are rewarded for their efforts in continuing their legal education and maintaining their competence in their profession.
We go now to those members of the bar who are exempt from the MCLE requirement as stated in Rule 7. These are, of course, the President and the Vice President of the Philippines, including the Secretaries and Undersecretaries of the Executive Departments, Governors and Mayors. Note also that the Chief State Counsel, Chief State Prosecutor, Assistant Secretaries of the Department of Justice, the Solicitor General, and the Assistant Solicitor General are exempt from the same. In the Legislative Department, Senators and members of the House of Representatives are similarly exempt from said requirement. On the other hand, in the Judicial Department, the Chief Justice and Associate Justices of the Supreme Court, incumbent and retired members of the Judiciary, incumbent members of the Judicial and Bar Council, and incumbent court lawyers covered by the Philippine Judicial Academy. Even in the constitutional bodies, the Ombudsman, the overall Deputy Ombudsman, the Deputy Ombudsman and Special Prosecutor of this office, as well as chairmen and members of the constitutional commissions, are exempt. The Government Corporate Council, Deputy and Assistant Government Corporate Council, heads of government agencies which exercise quasi-judicial functions too are accepted from the MCLE requirement. And this includes incumbent deans, bar reviewers, and law professors with at least 10 years of teaching experience, and those who retired from the practice with IBP approval. Members of the bar which, however, are not in the practice of law, whether private or public, are excluded from the requirement, and members of the bar who have been granted exemption for good cause are likewise exempt. The causes referred to are physical disability, illness, postgraduate study abroad, and proven expertise in law. In these cases, exemption from compliance therewith may be requested, or even a mere modification of any requirement, including the extension of time for its compliance.
Rule 8 provides the standards for approval of education activities. Continuing legal education activities must meet the following standards. Number 1, the activity shall have significant current intellectual or practical content. Second, the activity shall constitute an organized program of learning, which must be related to legal subjects and the legal profession. And this also includes cross-professional activities that enhance legal skills or the ability to practice law, as well as subjects in legal writing and oral advocacy. And third, the activity shall be conducted by a provider with adequate professional experience. Fourth, where the activity is more than 1 hour in length, then there must be a substantive written material that must be distributed to all the participants, and such materials must be distributed at or before the time the activity is offered. And lastly, in-house education activities must be scheduled at a time and location so as to be free from interruption like telephone calls and other distractions. Also, under Rule 8, continuing legal education program may be granted approval in either of the two ways. First, the provider of the activity is an accredited provider and certifies that the activity meets the criteria of Section 2 of this rule, or the provider is specifically mandated by law to provide continuing legal education.
Under Rule 9, the accreditation of providers shall be done by the MCLE committee. Any persons or groups may be accredited as a provider for a term of 2 years, which may be renewed upon written application. All providers of continuing legal education activities, including in-house providers, are eligible to be accredited providers. All approved accredited providers shall agree that an official record verifying the attendance and the activity shall be maintained by the provider for at least 4 years after the completion date. Approved accredited providers shall also maintain an official record of attendance containing the member's name and number and roll of attorneys.
Rule 12 on non-compliance procedures. Section 1 refers to the acts which constitute non-compliance. They are failure to complete the education requirement within the compliance period, failure to provide attestation of compliance or exemption, failure to provide satisfactory evidence of compliance, including evidence of exempt status within the prescribed period, failure to satisfy the education requirement and furnish evidence of such compliance within 60 days from receipt of non-compliance notice, failure to pay non-compliance fee within the prescribed period, any other act or omission analogous to any of the foregoing or intended to circumvent or evade compliance with the MCLE requirements.
A member who fails to comply with the requirements after the 60-day period for compliance has expired shall be investigated for non-compliance by the IBP's Commission on Bar Discipline, the fact-finding arm of the MCLE committee. Members on this list will be subjected to the following consequences. First, they will be subjected to the payment of non-compliance fee. Second, they will earn the status of delinquent member. A member listed as delinquent shall pay a non-compliance fee of 1,000 pesos. Membership fees are not suspended and shall continue to accrue active rate against a member during the period he or she is listed as a delinquent member. So it's in your best interest to comply or reinstate yourself ASAP. You must simply and calmly provide proof of compliance with the deficient MCLE requirement. And, most importantly, pay the non-compliance fee. Once the member submits proof of compliance to the IBP Board of Governors, they will notify the MCLE committee of the reinstatement.
What is the MCLE committee composed of? It shall be composed of 5 members, namely a retired justice of the Supreme Court as chair, and 4 members respectively nominated by the IBP, the Philippine Judicial Academy, a law center designated by the Supreme Court, and associations of law schools and/or law professors. The members of the committee shall be of proven probity and integrity. So what are the duties of this committee? They shall administer and adopt such implementing rules as may be necessary subject to the approval of the Supreme Court. It shall, in consultation with the IBP Board of Governors, prescribe a schedule of MCLE fees with the approval of the Supreme Court.
The MCLE may employ staff members for, among others, record keeping, auditing, reporting, approval, or any other position that the committee may deem proper for the performance of the functions of the committee itself. The committee shall send to the Supreme Court, subject to their approval, an annual budget that the committee may deem proper for their subsidy to establish, maintain, and operate all programs in the MCLE.
Ignorance of the law excuses no one, especially lawyers. It is important for all lawyers to keep up with developments and changes in the practice of law. This has been Things You Need to Know about the mandatory continuing legal education requirement. Thanks for listening.